Welcome to Leveraging Inspiration, the Inspired Patent Podcast, where we explore the world of innovation, creativity, and intellectual property. I'm your host, Wayne Carroll, and I'm excited to bring you insights and stories from the successes and failures of others so you can protect your inspired ideas. Thank you for joining me. This is directed to small businesses who typically don't have in-house counsel. They need to rely on attorneys. And I'm here to give you some information so you can make the best decision possible for your business. So before we get started, I'm an attorney. I have a disclaimer. This is a podcast and not a legal consultation. This is not legal advice. This is for educational and informational purposes only. If you want a consultation, call me. We'll do that one-on-one, but I'm not providing legal advice right here, and nothing in this podcast should be construed as creating an attorney-client relationship. With that disclaimer out of the way, let's dive into the world of intellectual property, patents, innovation, and your inspired ideas. We are on week 2, and this is episode 6 of our journey together. So we're going to talk about avoiding costly patent mistakes, pro help and tips on patent research. So there was an inventor that I worked with. He didn't want to do the research, and he convinced me that they really knew the industry and that they knew the market well enough, and there was nothing on the market that would be similar to their invention. So we went forward with a patent application without doing the research, and of course, patent applications are not cheap. They cost thousands of dollars. And when the patent office examined the patent, they found an old patent with a very similar invention. And the inventor did not get the patent. So I want to help you learn how to do some of the research on your own and how to work with a professional to reduce the risk that you will invest in a patent application that is not going to be granted. So not all patent applications are created equal. Some patent applications are out there, or some researchers are out there that are doing a very low quality. Let me explain the standard of what we're looking for in a patent research. First, you have to understand, what is it we're trying to find? So a patent needs to be new and non-obvious based on the state of the technology. And they say the state of the technology is what's been published. So the internet is publishing like crazy. That's publications. Even if it's in another language, in another country, if it's available to the public, it's a publication. So there are researchers that have access to those databases, and there are some simple databases that you can use on your own. There is the Patent Office, but actually it's better now that Google has taken all of the Patent Office data. Now, they might not be 100% up to date, and we're going to talk about how up to date you can be anyways. So they might be a few months behind of what's been published by the Patent Office, but you can search at patents. You got the wrong one. So you can do some of the research on your own. And the researchers that have better research tools, that have better databases, that are set up, when the Patent Office does a research, they first determine what is the category of this invention. And actually now they're working on having a couple different categories, but they're going to first search patents that are in those categories. And so patent researchers should look there as well first. The goal is to make sure you don't have any surprises from the Patent Office as well as surprises later on, because any publication prior to your patent application date in any country in any language can be used not just to reject your patent application, but it can be used later to invalidate your patent. And we've talked about a couple times the 1-year grace period for the inventor's own publication. So that does exist. So they don't, if the patent office finds something and you can show them, hey, that was my publication, so you can't count that against me. But anybody that publishes before your filing date, even if they publish after you published, is going to count against you and can block your patent either in the patent office or later invalidate it if the patent office didn't know about that. So the other thing to understand is that when the patent office reviews your patent, they're searching patent claims. And those are, I don't know if you've read a patent, but when you go there and you look at a patent, at the end of the patent, actually on the Google site, they put the claims on the right-hand side of the page, and they're numbered paragraphs. And so the patent office, they're searching for what those claims cover. And if your research doesn't cover those claims, because what often happens is we do research at the beginning, we work on the patent application. If what we work on veers far enough away from the research we did, we really should do more research. So that's one of the things to consider is keeping track of, is your patent changing? Because sometimes it changes. You start working on the patent application, working with your patent attorney, and then a month later you say, hold on, we're changing things. I advise checking to see, did that change require a new patent search? And even though I definitely encourage that's all they do is do patent searches. And they have access to the databases and all that. Every inventor does their own research. You have an idea, you look, is this been done before? It's a great idea, and you can't find it. That is research. And one of the things I encourage you to do is write down what you find. What's the closest thing? You can show that to your attorney, and that, first of all, you are actually required to show that to the patent office if it ends up being relevant and kind of similar to what the claims are. So we don't know for sure, but it's safer to just disclose things. So if you knew about it and you didn't tell the patent office, that's one of the easy ways for a patent. There is no perfect patent search. One of the reasons is that patents, when they're filed, and this is pretty much globally, they aren't published for 18 months. There's a treaty that's with over 150 countries, a patent treaty, where it says if an applicant wants to be part of this treaty, so an inventor filing a patent application, if they want to be part of this treaty, they need to allow their patent application to be published 18 months after it's filed, even if it's not examined yet, if it's just still pending, the patent office hasn't even looked at it yet, it still needs to be published. And so for that reason, the default in the US is that it gets published, and you can opt out of that, which also opts out of foreign patent filings. For small businesses, that often makes sense. But what that means is when you're researching when you're researching to find prior inventions to see if your invention is new, there's at least 18 months of what's been filed in the patent office that's considered before yours, but you can't see it. That's a blind spot we just can't eliminate. So it's just part of the risk and part of what I want a patent. The one other thing that I wanted to mention is that what a lot of firms a lot of patent firms are set up to help the big businesses. Big law firms are often focused on finding and hiring big businesses. They'll take the business from the small businesses, but are they really set up to help that small business, to help them through what they need to do and the decisions they need to make? Large businesses typically have internal processes to go through some of the things that an attorney can help you with, but if they're not set up to do that, if they're not set up to help small businesses, then they often won't help you go through those steps. And we, of course, at my law firm, that is who we focus on, is the small business, the business that's still growing, and we help them. We have a proven process focused on strategy at every stage of the case, so that we make sure you're going through those strategic decisions that larger companies go through internally. And we work through those in a way that works for small businesses with their budget and their time. So I encourage you to consult with a patent attorney when you're reviewing an invention that knows the current state of the law and can guide you on a strategic decision of whether or not to file a patent. I'm Wayne Carroll, and this is Leveraging Inspiration, the Inspired Patent Podcast.